You know what's been happening more and more lately? Trust administrations are getting messy. Beneficiaries aren't getting along, attorneys are getting called in early, costs are climbing, and the trustees, well, they're under the microscope. So today, let's talk about what it actually means to breach your fiduciary duties as a trustee in California. Because if you're a trustee, you don't get to do your best. You are legally required to do what's right and to do it well. Before we go further, I just wanted to say thank you very much for watching. Be sure to hit the like button and subscribe for more. Sharing the video also goes a long way in helping us get this information out there, but without further ado, let's get into it. If you're a trustee, well then congratulations. You've just signed up for one of the most serious legal roles in California law. Sounds a little spooky, but the title comes with a fiduciary duty, which basically means that you must act in someone else's best interests, specifically the trust beneficiaries, one of which may even be you. If you are the trustee and also one of the beneficiaries of a trust, you have a duty to put the interests of all the beneficiaries above your own, but to do so with fairness and impartiality. That means you have to treat all trust beneficiaries equally, which just means that even if you were both a trustee and a beneficiary, you still cannot act only in your own best interest. Now, your fiduciary duty to the trust beneficiaries is not just a suggestion, it's enforceable in court. And it includes a whole bunch of responsibilities. The duty of loyalty, the duty of impartiality that I just discussed, a duty of prudent investment, duty to keep records, a duty to communicate to all the beneficiaries, and yes, a duty to provide an accounting. And let's focus on that last one, because that's where a lot of trustees unknowingly veer off course and get themselves into trouble. Under California Probate Code Section 16060 and 16061, a trustee must keep beneficiaries reasonably informed, which means more than just picking up the phone every once in a while. If you're managing someone else's inheritance, you must provide a formal, detailed accounting if requested, or if the trust is silent, at least annually or upon the termination of the trust. So the question is, what does that accounting need to include? Well, here's a very non-exhaustive checklist. The starting asset balances, all income and receipts, including rents, dividends, and sales proceeds, all disbursements, such as mortgage payments, repairs, distributions, things like that, gains or losses on the sale of trust assets, trustee compensation, if any is taken, fees paid to professionals, such as attorneys or accountants, if any was paid, and the ending balance of the trust assets. This accounting must also be clear enough that a beneficiary could reasonably evaluate how the trust was managed and whether there is any funny business going on. Which brings us to what constitutes a breach in the first place. There are a lot of ways to mess this up, not all of which are malicious. Some are just careless, but courts don't always draw that distinction, so let's go through some of the big ones. Failing to respond to beneficiaries. If you're not answering questions, providing updates, or delivering an accounting when required, well, guess what? You're in breach. Mismanagement of assets. That could be investing trust money in your friend's startup, selling real estate without a proper valuation, or for way less than what you should, or letting assets sit in a checking account earning nothing in interest over a year. Self-dealing. Using trust assets for your own benefit, even temporarily, or just to keep it safe. It's a serious no-no. Unreasonable compensation. Taking trustee fees that are out of step with the trust's size or complexity without transparency, well, you can expect some pushback. Commingling funds. Mixing trust assets with your personal money, well, that's a huge red flag. And the one that gets missed all the time, failing to communicate. Trustees have an affirmative duty to keep beneficiaries informed. Silence can be interpreted as hiding something, even if there's nothing to hide. So much time and money could be saved if trustees were just better at communicating with beneficiaries. And I say it's affirmative in that you have to be proactive in that communication, not just wait until somebody bugs you about stuff. Now, here's the reality. Trust litigation is on the rise, and frankly, some of the cases being filed are a little creative. Lawyers are poking at every little crack in the process. That vague email you sent, that unclear spreadsheet, that delay in sending distributions, each one is now an opening, and even if you haven't done anything wrong, the appearance of wrongdoing is enough to drag you into court and to cost you and the trust thousands in legal fees. That's why being proactive matters. If a court finds that a trustee breached their fiduciary duty, your consequences, they can be harsh. You could be removed as a trustee. You could be personally liable for any damages the trust incurs, even if you didn't profit from the mistake. And in some cases, you may owe punitive damages, especially if the breach was intentional. And no, a no contest clause in the trust won't protect you from a valid claim. Beneficiaries still have the right to question your actions, and courts still have the power to intervene. No contest clauses generally address a beneficiary's right to challenge the validity of a trust. It does not prevent the beneficiary from challenging a trustee's actions in managing the trust assets during the administration. So here's the bottom line. Being a trustee isn't just about doing the right thing. It's about doing it the right way and documenting it clearly along the way. Because when things go wrong in trust administrations, they go wrong fast and they cost a lot of money. And even if it wasn't your fault, you're the one with the legal responsibility and the legal liability. If you're a trustee and this all feels overwhelming, that's normal. Most people, they don't do this every day, but we do, and we're here to help. Keep in mind as well, if you're the trustee of a trust and you hire an attorney to help you, well, one, that's somebody in your corner to hold your hand through the process and prevent things from spinning out of control. And two, their fee, that's a trust expense, not something that you owe personally. Remember, a well-run trust is a gift to your family. A poorly run trust, that's a lawsuit waiting to happen. Be sure to like and subscribe, share the video with someone you know who's stuck being a trustee of a trust. I'm attorney Andrew Bethel, and I'll see you at our next meeting.